Hey everybody, today's question is, what if my patent application gets rejected? What do I do? Hi, I'm JD Houvener, owner and founder and patent attorney here at Bold Patents Law Firm, also the author of Bold Ideas, the Inventor's Guide to Patents. I got that book, the whole PDF, at the link below. So click it, it's our Bold Inventors Kit, and get your start today. So let's dig into this question a little bit. Rejection never feels good, right? It's like human nature, getting shut down by that date, right? That potential individual you're trying to get close to, a rejection at, say, a college or university you're trying to get into. This feels really bad, right? When you get that negative feedback, it hurts. Now, a rejection in the patent world is actually a good thing. I know you're thinking this is like, okay, what are you talking about? Why would I want to get rejected? I want that patent. I want to have that protection, that exclusivity that everybody's talking about, right? Up to 20 years of monopoly. And the examiner says, no way, you're not getting through. And sometimes those things, those rejections, can be quite detailed and intimidating. In fact, about 15-20% of our new clients that come find Bold is that they get a rejection. They file their application on their own, and now they're faced with a examiner that says their invention isn't new. Or on top of that, that it's obvious given prior art. And so how do you combat these? How do you prepare yourself mentally for getting rejected? So first off, if the patent application was drafted broadly, meaning the claim that you're asserting, that you're saying this is my invention, well, too broad means you've written a claim that is too big and is now stepping on the toes of other prior art, previous patents, previous publications, or information that is out in the public already, part of the public domain. The examiners are well instituted, right? They understand each industry you're filing into. So they understand the technology and the state of the art for each art, every single scientific area. So whatever you're filing your patent application for, got to make sure you've done the diligence. You've done some research ahead of time. Maybe you hired a patent attorney to do a patentability opinion for you, so you know exactly where your lane is. So that specific boundary of where you're claiming, you can have confidence that you're going to be sort of avoiding a specific rejection. But it's never possible to fully appreciate what an examiner's own personal opinion is. Even if you talk to the patent attorney and get their opinion, an examiner may look at it differently. They may see a piece of prior art and think that it does perform the same basic function or has enough there along with another 2 or 3 references to be able to make a rejection based on non-obviousness. So there's a lot that goes into rejections, so that they are quite common. And this is an astounding fact we put up on our website too, that on average, patent applications get 2.1 rejections. I know it's weird to say 0.1, but they get at least 2 rejections before they get approved. That's the average, that's typical. So yours might even have more than that. So just know that it's quite common. It is a natural push and pull between the examiner's motivation of making sure that nothing gets through that shouldn't, and the inventor and the attorney advocating for them to make sure that they urge it, push that application through. And so through maybe subtle amendments or through legal arguments, declarations, and interviews with examiners, you can finally get that patent application pushed through and issued. So don't be afraid of rejection. Give us a call if you're intimidated. We're happy to help. All right, everybody, have a great day. I'm JD Houvener with Bold Patents Law Firm. Go big, go bold.